Today on Star Hydro Power Limited against the National Transmission and Dispatch Company Limited.
Mr. McClure.
May it please the Court. Star Hydro submits that the Court of Appeal judgment was correct for the reasons given by the Court of Appeal. Specifically that Article 5 of the New York Convention is a shield to be used against applications for the recognition and or enforcement of an arbitral award, not a sword by which an award may be attacked preemptively, and that this determination is an English law question because the arbitration was seated in London, and thus England and Wales is the curial law, and that as a result, challenges to an award are only to be those permitted by English law. And so we will invite you to dismiss the appeal.
Yes.
As an outline of where we're heading, at the end of our written case, we set out 7 reasons or propositions that in our submission should be the basis for dismissing the appeal and upholding the injunction issued by the Court of Appeal. Our plan for this oral submission is to use those 7 propositions as our structure and to take each point in order. I will address you on the first 5 of the propositions, and then I'll hand over to Ms. Parrott, who will address you on propositions 6 and 7.
Yes.
But before doing that, I would like to set out some of the background relevant to how we got here today. My learned friend did some of that towards the end of his submissions yesterday, but there are some additional points that I would like to highlight and that in my submission are relevant for your consideration. Just starting with the background before I go to my propositions. The contract between the parties is called the PPA, the Power Purchase Agreement. And pursuant to that contract, Star Hydro agreed to build and then operate a hydroelectric power plant in Pakistan. Star Hydro funded the entire build itself with cash and equity. And the structure of the PPA was then that it would be paid for the electricity it generated from the complex and thus recoup its investment. As my learned friend said yesterday, electricity is a regulated industry in Pakistan. The regulator is called NEPRA, and NEPRA approved the PPA before the parties signed it. And that included the arbitration clause in the PPA and the Schedule 1 of the PPA, which sets out the details of the tariff that Star Hydro could charge for the electricity it generated. Now, Schedule 1 of the PPA is a complicated document, but in essence, it sets out various formula to be applied to calculate the ultimate amount Star Hydro is entitled to charge for the electricity it generates. And a significant input into the Schedule 1 formula is what is defined as the project cost, which forms part of the capacity price. And of relevance to this dispute was paragraph 5.2 of Schedule 1. I'd just like to show you that briefly. It's page 305 of the bundle. And 5.2 provides that the capacity price shall be adjusted at the commercial operations date as provided in Annex 5. And then this is the only other point I propose to show you in the Schedule 1. If you go to page 329, you get the first page of Annex 5, which is the adjustments on the commercial operation date.
Sorry, which was that page reference?
329.
329.
However, what happened is that after COD, the commercial operations date, not only did NTDC and NEPRA not apply the Annex 5 adjustments properly, they also sought to make an additional downward adjustment not contemplated for in Annex 5, in particular trying to adjust the exchange rate for certain onshore works from the pre-agreed US dollar amounts to a Pakistani rupee amount. Given the way exchange rates had moved, that had a significant impact. And then what we say is the wrong application of Schedule 1 of the PPA was then gazetted in Pakistan, as you heard yesterday. That gazetting was done by the government of Pakistan, and they are the 88% owner of NTDC. Star Hydro was not involved in that gazetting process. And so that prompted Star Hydro to commence the arbitration, seeking what it said was the correct application of Schedule 1. And you were taken to the award yesterday, but there are a few extra parts of the award that I would like to highlight for you. The first is paragraph 132, which is on page 396. And in particular, I'd like to direct you to the bottom of that page. So 132 starts at the bottom of the page. And then if you go in paragraph 132, the sole arbitrator is making reference to NEPRA's approval of the PPA before the party signed it. And then if you go over the page, he quotes a particular part from the approval. And that is the approval of NEPRA, not only approving the power purchase agreement, but also approving the other terms and conditions, indexation and cost escalation of civil works as agreed between the parties and contained in Schedule 1. That approval comes before the parties signed the PPA. The next point I want to take you to in the award that you weren't taken to yesterday is paragraphs 392 and 393. They're on pages 448 and 449 of the bundle. This is in part of the arbitrator's analysis of whether he was entitled to interpret Schedule 1. And at paragraph 392, he notes that reading the above provisions, these were the provisions of Schedule 1, their plain and ordinary meaning, it would be logical to conclude that the PPA sets out all the elements necessary for calculation of the tariff, and that the parties were at liberty to undertake this exercise themselves. They would not conclude that this was a role reserved for NEPRA or any other third party. And this is particularly the case given that, as pointed out by Star Hydro, NEPRA is a defined term in the PPA, and it's given other specific roles in relation to the PPA. And then it quotes from the transcript from the hearing. The other roles that NEPRA perform under the PPA are not particularly relevant today, or indeed at the hearing. They were there to impose what's called a supplementary tariff in certain circumstances that didn't materialise on the facts, or to impose different indexes if certain indices ceased to be available. But the point that was being made and that is being quoted here is that they were given some roles in the PPA, but they weren't given a role for calculating the COD adjustments. And then at 393, the sole arbitrator goes, as far as the contract concerned, that position is sound. There's no indication from the PPA that Star Hydro is at the mercy of a third party for the performance of the contract, at least as it relates to the adjustments to be made at COD. Then the next paragraph I'd like to show you in the award is paragraph 378. That's on page 446 of the bundle. You were taken to part of this paragraph yesterday, but in my submission it's important that you're aware of all of it, and I would ask you to take note of all of it. So paragraph 378 comes after paragraph 377, which is central to my learned friend's case. And the sole arbitrator there notes that with respect to the past, a declaration as to the consequences of the application of the PPA would serve a practical purpose for the claimants. it would give rise to a contractual claim for the delta between the amount which should have been paid and what has actually been paid to date. And it says, notwithstanding NTDC's public-facing role, it's still a commercial entity. And that's where my learned friend stopped yesterday. But the rest of the paragraph in my submission is important. So NTDC has voluntarily entered into a commercial contract, and it cannot escape the implications of the terms it's agreed to. If that means that money is owed to Star Hydro, then that sum is due as a matter of contract. And he notes, as the claimant's legal expert, Justice Arab, points out, Justice Arab is a former Pakistan Supreme Court justice. The law does not prevent the payment of contractual damages. Further, he explains in his report that NTDC, in its capacity as a legal person, has the freedom to enter into any contract for the purchase of goods and services in relation to its regulated activities. If any costs or part thereof under such a contract are not approved as part of its various tariffs by NEPRA, NTDC would still be liable to its counterparty under such.
Does NEPRA also set the price at which NTDC sells its electricity to consumers in Pakistan?
I believe it does, yes.
Yeah. So it has to, and does it pay for its electricity out of its income from consumers? I mean, there are two models. It could be all come out of the consolidated fund, what goes to you, and then what the consumers pay goes into the consolidated fund, or it's described by the arbitrator as a commercial entity. So does it have to collect in from consumers what it pays out when buying electricity?
I might need to come back to you on that. I think that's right. That's how it works, that its income comes from consumers. And of course, as a government entity, it's able to draw on other funds from the government as well.
Well, it may or may not be.
Yeah.
But, all right. Well, if you don't know, that probably means it's not relevant. And
then the final paragraph paragraphs I wanted to take you to from the award are paragraphs 475 and 476. They come on page 467. And this is about the damages claim. At 475, the sole arbitrator knows that having determined the project costs and the tariff at COD that result from the application of the contractual mechanism at Schedule 1, the claimant's claim for the balance between what NTDC has paid and what it would have been paid must next be considered. And he notes at 476 that he agrees with the claimant that having determined that the tariff that arises from the application is higher than that currently being paid, the claimant's entitled to the difference between what has actually been paid since COD and what it should have been paid based on the tariff at 10.3632, which is the rate he found as a matter purely of contract. Star Hydro has received less by way of tariff payments than it is entitled to under the PPA. Now, my learned friend also said yesterday that Star Hydro's reliance on the award put his client in a very difficult position because it could not pay Star Hydro anything different to the gazetted amounts. I say that submission's not open to him. Not only is it contrary to the findings of the sole arbitrator and the expert evidence of former Pakistan Supreme Court Judge Justice Arab, quoted at paragraph 388. NTDC's own past conduct strongly suggests that they can pay if they want to. And I say that because of the previous arbitration between the parties. Now, that previous arbitration concerned who was responsible for delays to the construction of the project. And a different sole arbitrator found that NTDC was responsible for those delays. You'll recall my learned friend mentioned that arbitration yesterday. Now, the contractual formula for delay damages is set out in section 6.5b of the PPA. We don't need to turn it up, but the reference, so you have it, is on page 218 and 219. And that provides for two types of payments, depending on the length of delay, which the parties defined in that other arbitration and in subsequent court proceedings as delay damages and principal debt damages. And you heard yesterday that when Star Hydro took that award to the Lahore court for enforcement, the Lahore court raised a concern about the second of those payments, the principal debt damages. And it's our submission that if you read the Lahore court judgment, that the concern was about an issue the Lahore court had with double recovery as opposed to arbitrability. And we set out why we say that at paragraph 9D and footnote 15 of our written case. Now, I don't propose to rehash now the point about whether it's double recovery or not. I'm happy to leave it with what I've put in writing. But just for a moment, assume that I'm wrong and it's not about double recovery. And instead, that other case stands for the proposition that my learned friend says it does, which is that half of the previous award between the parties concerning delay to the project was unenforceable as a matter of Pakistan law. It must then follow that NTDC cannot pay it. After all, we heard yesterday how they cannot pay any sums owed that are contrary to what is Pakistan law. But that's not what happened. They paid the full amounts owed, and they paid that under a settlement agreement dated the 5th of May 2024. And that's in your, I won't turn it up, but it's in your bundle, so you have the reference at 4667. And in my submission, it's of relevance for you to note that that settlement agreement came 14 days after Star Hydro had established that the government of Pakistan was liable to pay the same sums owed under the sovereign guarantee between Star Hydro and the government that sits behind the PPA and pursuant to which the government guarantees all of NTDC's payment obligations under the PPA.
How is that enforceable? Is that subject to arbitration?
The settlement agreement or the guarantee?
The guarantee.
Guarantee arbitration. Yes. So having been successful in the arbitration about who was responsible for the delay, making the demand on the payments, NTDC didn't pay. Star Hydro then commenced a separate arbitration against the government under the guarantee. And then once that had run through to its conclusion, very shortly thereafter, NTDC paid.
Presumably your clients are using the same method in this particular case too?
We are indeed, yes. So my submission, it's important to note that the full amounts were paid under the previous arbitration. The next bit of background that I'd like to direct you to is in relation to my learned friend's submissions yesterday that Star Hydro requested a declaration for a tariff that he says was dismissed. This is what was described as his major partial victory. We say that's wrong, and it was no victory at all. We set out the reasons for that in detail in our supplementary skeleton before the Court of Appeal. And I'll give you the reference so that you can look at that in more detail before giving you a brief summary of what we say. So the reference for where we say that in detail is paragraph 6 to 13, pages 820 to 822 of the bundle. But the short point is, in our submission, Star Hydro only ever sought a declaration of the tariff as at COD, according to Schedule 1. and payment of the delta up to the date of the award. We say that's clear from the relief Star Hydro sought in the award. And we further say that nothing should be read into the fact that the sole arbitrator didn't include the word entitled in the declaration at paragraph 514. And I say that because of paragraph 234 of the award. And if we could go to that briefly, please. It's page 417. At this part of the award, the sole arbitrator is summarising his understanding of Star Hydro's claim. And he says that Star Hydro's primary position is that NTDC has breached the PPA for failing to agree the mechanism for adjustment as set out in Schedule 1 or failing to make payments. But for this breach, Star Hydro submits it would have been receiving the tariff payments which it's entitled to. It therefore claims that it's entitled to a declaration of the tariff at COD in accordance with Schedule 1, as well as contractual damages in the form of payment of the balance between the tariff payments to which it claims and is entitled and those that it's actually received with interest. And so in our submission, we say it's clear from this that the sole arbitrator did not consider or find that Star Hydro was not entitled to payment based on the COD tariff he declared. On the contrary, he ordered payment on that express basis, and he said it in terms in paragraph 476, and maybe we could just jump back to paragraph 476. We looked at it a moment ago, page 467. The sole arbitrator agrees with the claimant that having determined that the tariff which arises from the application...
Sorry, where are you?
476,
yes.
Second penultimate paragraph at the bottom.
Yeah.
Agrees with the claimant that having determined the tariff that derives from applications higher than that currently paid, claimant is entitled to the difference between what has actually been paid since COD and what it should have been paid based on the tariff at 10.36 as a matter purely of contract. Star Hydro has received less by way of tariff from NTC than it is entitled under the PPA. And so in our submission, there's no victory at all, whether partial or otherwise, in relation to whether Star Hydro is entitled to a declaration as to the interpretation of Schedule 1. Now, to a point that came up yesterday, Star Hydro accepts...
Is that a matter for us to determine? I understood Mr. Landau to be making these points in order to explain the form of relief that was being sought in the proceedings in Lahore, where he does wish to maintain, I mean, he may not be right about this, but the argument, as I understood it, was that the appellant would wish to maintain that it, in fact, was a partial victory for them, and hence that they wanted partial recognition of the award. So I'm just not quite sure whether the arguments you're addressing to us now are things that we need to resolve, or that they affect the analysis overall, which we have to embark upon.
I raise it first to correct what was said yesterday, as I don't feel it was an accurate submission. It becomes relevant as I build up the points in my proposition. Our submission is that you should be looking at the form of what's being asked for in the Lahore proceedings and not... Sorry, you should be looking at the substance of what's being asked for in the Lahore proceedings and not the form. And to that specific point, my lord, as to whether he's taking the award as is, we say that as a matter of substance is not correct if you look at what is being done in the Lahore proceedings. And I do plan to go through that in a moment.
All right. Thank you.
But just before I turn up the Lahore proceedings, one other bit of background that I wanted to address you on concerns invoices. And it was said a number of times yesterday that NTDC is pursuing the Lahore proceedings because they want Star Hydro to stop invoicing them based on the COD tariff declared in the award. My learned friend said, and I'm quoting here, they keep issuing invoices, so the step was taken to ask the Pakistan court for partial recognition, and we're asking for partial recognition of this because basically we want them to stop invoicing us. And my learned friend did row back from that at the end of the day and say that Star Hydro stopped invoicing NTDC when the Lahore proceedings were commenced. And they actually stopped shortly before the Lahore proceedings were commenced. And I'd just like to give you a bit of context around that. Now, during the arbitration, not only did Star Hydro claim for the delta of what it claimed was owed from the correct application of the tariff, but it also claimed interest on that amount. And that interest was significant due to how it's calculated by reference to moving exchange rates and the compounding nature of it. And the interest claim was around $80 million. And NTDC's defense to Star Hydro's interest claim was that Star Hydro had never issued invoices for the disputed amount. So Star Hydro had never issued invoices for what it said was the correct application of Schedule 1. And you can see that at paragraph 364 of the award. If we turn to that briefly, it's page 444 of the bundle. That's a summary of NTDC's defence that Star Hydro should not be entitled to interest because they hadn't issued invoices for what Star Hydro asserted was the correct amount. And the sole arbitrator agreed with NTDC on that point. They were successful. I won't turn it up, but the reference, so you have it, is paragraph 480 of the award, page 468 of the bundle. And so, post-award...
Can you just give that reference again, sorry?
Oh, sorry, sir, my lord. It's paragraph 480 on page 468 of the bundle.
Thank you.
And so not wanting to be caught in the same position again, post-award, Star Hydro did start issuing invoices. Now, Star Hydro usually issues invoices monthly.
Sorry, and invoices for what exactly?
The tariff payments.
Right.
So the way it works is that every month Star Hydro issues invoices for the amount that it says it's...
So did it then issue an invoice for the pre-award amount, or just
going forward, presumably?
Yeah, so it issued a demand for the post-award amount. Sorry, for the pre-award damages that Star Hydro said was ordered, and then going forward, it tried to issue for what it said was the correct amount pursuant to the sole arbitrator's interpretation of the PPA. So Star Hydro issues invoices monthly, and that's because there's various factors that go into the actual amount it's due per month based on the various indices, applications, and of course the project cost is a big part of that. So the award was dated the 7th of May, 2024. So the next billing cycle or invoicing cycle is at the beginning of June. And so what Star Hydro did at the beginning of June was it issued two invoices. It issued one for the gazetted net per amount and one for the delta between what Star Hydro said it would have been due that month following the arbitrator's interpretation of the PPA. Now those invoices are dated the 3rd and 4th of June. And they're in the, I won't turn them up, they're in the bundle at page 623. But I do ask you to keep a note of the date, that they're dated the 3rd and 4th of June, and I'll come back in my submission to why I say that date's important.
And so Gazette amount is 3rd of June and the delta is the 4th of June. Is that right?
Correct, my lord, yes. And then there was no immediate response to those invoices. Star Hydro followed the same process in July. So it sent 2 invoices on the 1st and the 8th of July. They're actually not in the bundle, but there's a reference to them in the statement of facts at page 40. And then on the 19th of July, Star Hydro received a letter from NTDC which asserted that its June invoices had not been in accordance with the PPA. And that letter is in your bundle 4695. And pursuant to that letter, NTDC is refusing to pay any of the June invoices, so the gazetted amount and also the balance amount. And so if you want, in my submission, if you want to talk about a party being put in a very difficult position, it was Star Hydro and not NTDC. And I say that because my client needs to receive some capacity payments from NTDC so it can continue its operations. It needs to repay its staff, it needs to pay its lenders, it needs to keep the plant running. And so after receiving NTDC's letter of 19 July, Star Hydro stopped sending any further invoices connected to the COD tariff declared by the sole arbitrator, and instead reverted to issuing invoices only in accordance with the gazetted amount, and NTDC has been paying those since. And one more final point on invoices before we look at the Lahore proceedings.
So has it paid the June and July instalments?
Up to the gazetted amount, yes.
Yes, right.
Star Hydro had to go through a process of reissuing the invoices, but it has received the gazetted amounts for June and July, and indeed for all the amounts going forward.
But it may be losing out, you say, as a result of that, on the ability to claim interest on the amount that should have been paid but hasn't been.
That's correct, my lord, but also it's losing out because it's not getting what it says is the correct amount either, because it's being paid.
I appreciate that, but that can be claimed in an arbitration.
That's right.
But maybe the arbitrator wouldn't award interest on that amount if it's the same as before.
And then one final point on invoices that in my submission it's important for you to be aware of, particularly when considering the relief that's sought in the Lahore application, is that the PPA, the contract, is very clear about what should happen if a party disputes an invoice. And I just want to look at that very briefly. If we could go to page 238 of the bundle, and that's section 9.8 of the PPA. Hopefully this is the last time I'll need to turn up the PPA. Section 9.8a, Roman numeral 1. Section 9.8 is entitled Payment. Roman numeral 1 says the power purchaser shall pay the amount shown on an invoice on or before the 30th day that it's received. And then if we go down to 9.9, sorry, this payment obligation 9.8, as you can see, subject to 9.9. And then 9.9 is on the next page, and it's got a mechanism for what's called payment disputes. And it says at any time within 360 days after receipt of an invoice, a party may serve an invoice dispute notice on the other party. And then it sets out a process effectively to follow the dispute resolution process in the PPA, which is that you go to expert determination and then ultimately arbitration. So the PPA is very clear what you should do if you want to dispute an invoice. And in my submission, it's not for one party or the other to circumvent this procedure in the PPA by seeking to injunct the other from issuing invoices in the Pakistan courts. In my submission, that is a clear breach of the arbitration agreement, as the parties have agreed to exclude the jurisdiction of the Pakistan courts in respect of their invoice disputes. And that then brings me to the Lahore application itself, which is the final of my background points before I dive into my propositions. As you'll be aware, at paragraph 65 of the Court of Appeal's judgment, Lord Justice Phillips says the Lahore proceedings are a full-throated challenge on the final award. And at paragraph 69, he says that the suggestion that the proceedings are for recognition and enforcement is transparently false. It's the final sentence of paragraph 69. And so I just want to look at the Lahore proceedings. It's in the bundle and it starts on page 475. So on page 1, you can see in both the title of the document and in the first paragraph, it's said to be an application under the Recognition and Enforcement Act of 2011. As my learned friend said yesterday, that's the statute in Pakistan that implements the New York Convention. And then paragraph 1, the applicant, that's NTDC, seeks enforcement and recognition of certain findings, in particular paragraph 514I. And as you know, that's the final one of the 9 subparagraphs in the dispositive that says the sole arbitrator dismisses and denies all other claims and requests for relief. Then over the next few pages, it sets out some of the history of the parties, and there are select extracts of certain parts of the award. I want to take you to paragraph 35, which is on page 492. Towards the bottom of the page, that says that the sole arbitrator was misguided and wrong in finding, even if for discussion purposes, his contractual assessment could stand alongside NEPRA's determination of project cost. Contractual assessment it's not an actual defined term in the award, but it's defined in the Lahore proceedings 1 page back. So if you go back 1 page to 491, and at the final paragraph at the bottom of that page, paragraph 33, you get NTDC's definition of contractual assessment. And that's dispositive paragraphs A to D. And so those are all the main operative provisions in the award that are in Star Hydro's favour. We go back to the next page, so back to page 492. Paragraph 36 at the bottom of the page, it notes that the respondent number 1, so that's Star Hydro, incorrectly believes that the sole arbitrator's contractual assessment is binding and was meant to override NEPRA's determination. And then over the page, the paragraph concludes with NTDC's arguments for why the contractual assessment should not be binding, with assertions that it's contrary to various Pakistan statutes, and then also Article 5 of the New York Convention. And I draw your attention that it's Articles 5.1 and 5.2. Next paragraph that's relevant in my submission is paragraph 39. That comes 2 pages later on page 494. And there, towards the bottom of the page, it says, the cause of action in the instant application arose when the award was rendered. And I ask you to note this because part of NTDC's arguments now, before this court, is that it had to commence the Lahore proceedings because Star Hydro started issuing invoices. And it also argues that it's entitled to avail itself of the Article 5 defences because it says Star Hydro invoked the award by issuing the invoices against them. Now, we say that argument, first of all, that argument has not been made in writing by my learned friend before this Supreme Court stage, that the invoices were the trigger for the Lahore application. It was an argument he first made orally in the Court of Appeal. And the argument is wrong for the reasons we address at paragraph 55 of our written case. But the point I would like to highlight here is that before the Lahore court, NTDC is not asserting that its cause of action was premised on Star Hydro having issued invoices. It's arguing its cause of action arose when the award was rendered. Then if we go over to the next page, we get the prayer in the Lahore proceedings. And NTDC asks for 3 things.
Sorry, just on that, if the application is one for partial recognition and enforcement of the award, isn't it right that the cause of action arose when the award was rendered?
Yes, I'm highlighting the difference between what's written here and what's being said in the submissions. That it was the invoicing that required NTDC. Right,
but if I may insist, I'm not sure there's a contradiction or inconsistency between the two. I mean, one might have a factual trigger, if you like. What makes it worthwhile going to court is a particular factual problem. But at the same time, what you're seeking to rely upon is a cause of action which did indeed accrue when the award was delivered.
What I would say to that, my lord, is when we get on to looking at Article 5, it makes my learned friend's assertion that he can rely on Article 5 very difficult because he needs to establish, in order to, in my submission, to establish that he can rely on Article 5, Star Hydro has sought to invoke the award against him. So if his...
But for this part, as I understand the claim that was being made, the appellants wanted to have partial recognition of the award insofar as they say it was in their favour. That's not predicated upon Article 5 as such as a defence, is it?
No, I would agree with it up to that point, my lord. But then when we get into whether or not, as part of this application, NTDC could raise the Article 5 defences, in my submission, that it then becomes relevant.
All right, thank you.
Is it relevant to whether this is truly a preemptive application in Lahore, or whether it's not a preemptive one because actually they're seeking to enforce parts of the...
Yes, my lady, yes, it is. So then we get the prayer, which is on the next page, 495. There's 3 parts to the prayer. A, NTDC asks the Lahore court to recognise and enforce paragraph 514I.
I'm so sorry, I missed the page.
Oh, it's 495.
Oh, sorry, right, thank you.
The very next page.
Yes, thank you.
So, in part A of the prayer, NTDC asked the court to pass judgment and order and recognise the award. In terms of paragraph 30 hereof, and in particular, paragraph 514 I of the award. And so to the point you raised with me earlier, my Lord, and you raised it yesterday with my learned friend, as to whether my learned friend is taking the award as read, we say he's not. He's taking the award as per his terms of interpretation, as per his paragraph 30. And then he's using that to ask for the subsequent declarations. A1, about NEPRA only having the power to determine and approve the tariff. And then A2, consequently, that the assumption of the jurisdiction by the sole arbitrator for the contractual assessment, the nullity in the eyes of the law, and that accordingly, paragraphs 514A to H are neither recognisable nor enforceable under the Act. Then we have B, which is an alternative to A, asking the court to pass judgment that no amounts are payable. And in our submission, that runs expressly contrary to paragraphs 475 and 476 of the award. I took you to them earlier, but it might be worth just jumping back very quickly to paragraph 476. That's page 467 of the bundle. Where the sole arbitrator agrees with the claimant that having determined that the tariff is higher than what's currently being paid, claimant's entitled to the difference in what's actually been paid, and then the final sentence, Star Hydro has received less by way of tariff payment from NTDC than it's entitled to under the PPA. And so in our submission, that to even ask the Lahore Court for zero quantification is contrary to the provisions in the award. And then if we just jump back...
But again, I think the argument on the other side is they accept it's contrary to some of the provisions in the award, but not others. And clearly they are seeking to rely on Article 5 to defend themselves against paragraph 514D of the award, which I think was the damages amount, wasn't
it? If we go back to the prayer...
Page 495?
495. The prayer at B is put as in the alternative to A.
Right. I mean...
On any view, this isn't seeking to set aside the award, though. It's an argument about what the award does or doesn't provide for.
Well, it's our submission, my Lord, that in substance it's looking to denude the award of any effect to Star Hydro.
I thought they made... Sorry.
No.
I thought they made the point yesterday that actually what this was getting at was that even if you look at the arbitrator's calculation... Once you'd added in what they have paid because it's been indexed in some way or adjusted in some way, actually you have been paid everything, even if you apply the arbitrator's figure. That's what I understood them to be saying. So,
my response to that, my lady, is that's just not open to them, given 476 of the award that notes that Star Hydro has received less. The indexation is all part of the tariff calculation.
But the real question, which we haven't got to yet, I appreciate why you want to set out your side of the stall in Pakistan, but the real question is whether any of this has anything to do with us.
I heard that question yesterday, my Lord, and I will try to address you on that. It's my submission, it is.
I realise that.
Something to do with you.
But that requires you to say that it's our business to decide how recognition and enforcement should be given effect to in Pakistan. Or that that's one of your submissions as I understand it. The other is that actually when you read this, despite the fact that the Act only gives the court power to recognise or enforce or not, somehow this is asking the court to do something that it has no power to do.
I would agree with that, my lord, but I would add that I also ask you to look at what NTDC is doing in substance rather than form. And I will submit to you that the label, the fact that they've premised this as being under the 2011 Act, should not be determinative. And the substance of the application is that, as Lord Justice Phillips said, it's a full-throated attack and challenge to the award.
Well, what are they hoping to achieve if the only powers they're relying on are powers to recognise or enforce? How can they somehow use that power to nullify the award more widely than Pakistan?
Well, my lord, it's my submission that an attack or a challenge to an award is more than seeking nullificatory orders in foreign jurisdiction. The challenge can be looking at other things that seek to denude the award of its practical effect or to undermine the award. And I will take you to the cases to build up my submission, but it's the crux of our submission that the erga omnes test should not be the test. That what constitutes a challenge that you are entitled to injunct is broader than when a party is seeking erga omnes or set-aside relief in a foreign court.
I mean, are you essentially saying that this is not even a partial recognition, a partial enforcement?
In substance, yeah. As in, we are saying that the substance of the application is that it's looking for more than partial recognition and enforcement.
But even if that's right, the alternative way of looking at it is it's seeking non-recognition of the award, and unless you convince us it's for us to tell Pakistan what procedure it should operate, at the moment I don't see why they can't decide. It's not up to them to decide whether they'll allow a preemptive application for non-recognition or whether they won't.
That's my challenge, my lord. It's C&D and Integra, and I will try to build up that submission. I'm planning to turn to it right now. The final point on the application.
Can I just continue what I was asking? So you are conceding that they are asking for partial enforcement?
No, well, we're not conceding that it's partial enforcement. Our position is that substantively it is a...
It's no enforcement at all.
It's a non-recognition application.
Attack on, yeah.
Okay.
Well, your point is the award says they're entitled to a large amount of money. Sorry, you're entitled to a large amount of money, and they're trying to get the Lahore court to say you're not entitled to any money. And that's...
On no view can that be portrayed as enforcing the award, you say, or any of it?
Correct, my lady, my lord, yes.
I'm afraid I'm still a little bit puzzled as to why we shouldn't read the first paragraph of the prayer, paragraph A on page 495, where they positively ask the court to recognise and enforce the award, in particular paragraph 514, little 1. Why shouldn't we take that at face value?
My answer to that, my lord, is that it's not just those words, it's asking to enforce it in the terms of paragraph 30. And so they're not asking for interpretation of the award as is, they're asking for interpretation of their submission as to what the award means as per paragraph 30.
But I mean, I can see that there may be arguments about what the award means, but given that they want to present an argument which, if correct as to the meaning of the award, is indeed something that they would want to be enforced, I'm still not quite sure why we shouldn't take at face value the claim that they've put in prayer little a. I mean, I understand that you would say, well, they've misinterpreted the award, but that's going to be an argument that would need to be gone into in the Lahore proceedings on this claim form. But if we're looking to see what they are trying to achieve, why isn't it right to say they are trying to achieve partial enforcement of the award?
We would say that A2 belies what they're really trying to achieve, which is the nullity of all other parts of the award. So taking, if 514I, a paragraph that's common to many arbitral awards that dismisses and denies all other claims, using that to nullify the effects of every other operative part of the award is, in our submission, an impermissible challenge to the award.
But 514I is doing something. It's part of the dispositive. It's true that to understand what it's doing, you have to look back at what other claims have been presented, about which there may be argument. But insofar as other claims have been presented, the arbitrator has dismissed them. Isn't that right?
That is right, my lord. But to then take the next step to say that enforcement of that provision means that all of the other operative provisions of the award are a nullity, we say that in substance that is the attack to the award.
I see. All right, thank you.
And just finishing on the prayer, we then have C, which is the injunction to permanently restrain Star Hydro taking any action, including issuing invoices in relation to the COD stage tariff amount set out in the award.
Do you have to invoice in order to trigger the guarantee? But again, if you don't know, then that suggests it doesn't matter particularly. But I was expecting you to say we have to issue invoices if we want to go against the government under the guarantee, but maybe the guarantee doesn't require non-payment.
There's a separate demand process under the guarantee.
Okay.
I think I took you out of your course by asking you to look at the prayer again. You're going to take us somewhere else.
No, I'm going to dive into my propositions now. So there are 7 propositions.
Yes.
At the end of my case, and I'll take propositions 1 and 2 together. So proposition 1, that a choice of arbitral seat is also a choice of forum for remedies seeking to attack the award. And proposition 2, that an attack or challenge to an award in a foreign jurisdiction not permitted by English law can be restrained by an anti-suit injunction. And both those propositions come from C and D. And so I would like to turn up that case. It's in the bundle, starting page 1, the Court of Appeal decision, starting page 1203. And as Lord Justice Phillips said at 69 in the Court of Appeal, this case is an insuperable obstacle to mounting a challenge to a London-seated award in Pakistan. As you heard yesterday, the case concerned a dispute under the Bermuda Form insurance contract that was subject to New York law, but provided for disputes to be resolved by arbitration seated in London. The arbitrators found in favour of the claimant, but the defendant alleged that the tribunal's findings constituted a manifest disregard of New York law. and the defendant further intimated an intention to apply to a federal court in the US to make a claim to vacate the award, which was said in the case to be allowed under the US federal arbitration law. And in that case, both the High Court and the Court of Appeal proceeded on the assumption that it was correct as a matter of New York law. There was an argument available to the defendant to vacate the award in the US. The question was whether the defendant was entitled to exercise that statutory right to challenge the award in the US, given it was an English-seated arbitration. And both the High Court and the Court of Appeal concluded that the defendant could not pursue the statutory right in the US because the parties had agreed to limit their rights to make only challenges to an award as a matter of English law. And so,
I mean, strictly, the construction of the arbitration agreement is a question governed by the law applicable to the arbitration agreement, isn't it?
Yes, I would accept that, my lord.
As it was, as they decided, it was English law in this case. So no, we just apply our ordinary principles of contractual construction, and they construed the arbitration agreement as impliedly containing an implied agreement not to attack the award elsewhere.
Well,
presumably.
To that, my lord, I would say that the second part of that proposition from the judgment in my submission comes from the selection of London as the seat, and therefore the agreement to England and Wales being the curial law for the arbitration.
And you're implying, as a matter of interpretation of the agreement, that when you agree to arbitrate subject to English curial law, you're impliedly also agreeing that you won't invoke equivalent powers under some other law to seek to set aside the award.
I am indeed, sir, but that's in the context of, my lord, and in the context of this contract in C&D that was subject to New York law. So you've got the balance of the Bermuda form subject to New York law, but the selection of England.
Yes, but the arbitration agreement itself was governed by English law in C&D. So they didn't need to apply, as it happens, New York principles of construction. I'm not saying that those would necessarily produce a different view, but no particular attention seems to have been given to this point, but I'm just wanting, as a matter of correct legal analysis, to make sure that it's properly analysed. And it seems to me that as all this turns on what the agreement does or does, the arbitration agreement does or doesn't contain as a term, that question must be determined in accordance with the law applicable to the arbitration agreement as a matter of principle. You can't use some other law to construe the arbitration agreement other than the law which the parties have chosen to apply to it.
English
law. In C&D it was English law, as the court found. In our case it's Pakistani law, but I'm not apprehending that anybody's suggesting that it contains any different approach from English law, so we'll assume it's the same. But I just want to get the analysis correct, that's all. And this point seems to have been passed over in C&D rather. But
let me try and deal with that head on. I'll try and stitch it together by reference to the Court of Appeal judgment and then the first instance judgment. So if we start with the Court of Appeal judgment, paragraph 16, page 1210 of the bundle. Lord Justice Longmore there is noting that he'll deal with Mr. Hurst's argument in due course, but in my judgment they failed to grapple with the central point at issue, which is whether or not by choosing London as the seat of the arbitration, the parties must be taken to have agreed that proceedings on the award should only be those permitted by English law.
Yeah. That's a point about the content of the arbitration agreement, or scope, if you like.
It's also a point about the choice of the seat.
Well, yes, you're implying, as a matter of construction of the arbitration agreement, that by choosing a seat, they should be taken to have chosen to be subject to the curial law of that seat and not to other. And hence, then the reasoning flows from that, doesn't it?
Yes, it does. And so as he goes on to say, you know, in my view, they must be taken to have so agreed for the reasons given by the judge. And then he goes on, the whole purpose of the balance to be achieved by the Bermuda form, English arbitration, but applying New York law, is that judicial remedies in respect of the award should only be those, permitted by English law, and only those permitted by English law. Yes,
and if it had been Stockholm as the seat of the arbitration and Swedish law, then there would have been a similar, would have applied to, you know, that would have flowed through, wouldn't it?
Well, I would say to that, you would get there on the analysis with the selection of Stockholm as the seat.
So is this right? Are you saying it actually didn't matter in C&D whether the proper law of the arbitration agreement was English law or New York law? Because whichever one it was, there was a clear choice of London as the seat.
Yes, I am.
And it was really what flowed from the choice of London as the seat was and that's the only way you can challenge the award. And that would be true whether New York law was the proper law of the arbitration agreement or English law was the proper law.
Yes, my lord, that's exactly what I'm saying.
No doubt it would, but that assumes that New York law has a reasonably similar approach to interpreting contracts. Maybe most countries do to English law, but I mean, this is spelling out of the agreement to arbitrate in London, subject to English law, an implied agreement by the parties, isn't it? Whether you analyse that as construing the express words or implying a term on the basis that it was obviously intended or business efficacy, it's a contractual analysis. And the law that you're applying for that purpose must be the law that governs the contract under general principles of private international law.
Well, on that, my lord, maybe I could go to the the High Court judgment. So if we go to page 197 of the bundle, paragraph 42.
So just before we do, I'm now a little bit unsure. Was there a clear statement in the Court of Appeal what the proper law of the arbitration agreement was? I mean, and if so, did the Court of Appeal's reasoning turn upon that?
They did decide that the proper law of the arbitration agreement was English law. Yeah. They don't seem to have thought that that mattered.
Correct, my lord. So
could we just have the reference?
Paragraph 20, which is on the next page, 1211.
Yes.
And then there's a similar...
I think paragraph 29, they decide that Mr. Hurst's argument that the proper law of the arbitration agreement was New York law rather than English law cannot get off the ground.
Right. Okay, so it looks as though they did say English law was the proper law of the arbitration agreement.
But are we then saying there are potentially three laws that are relevant in this kind of situation? Because you could have an arbitration agreement governed by Swiss law. You could have the contract which you're arbitrating about being governed by Pakistan law, and you could choose London as the seat of your arbitration. So the London arbitrator would be sitting somewhere around here, but they would have to apply Swiss law to the arbitration agreement, construe the contract in accordance with Pakistan law, whatever I said. But then what would are you saying that the result in C&D would still be the same? You would still have to apply English law as the seat of the arbitration to decide what injunctions do or don't go to stop people doing things in other courts?
Yes.
Yes, it would still be English law regardless of the proper law of the arbitration agreement,
Yeah.
as well as regardless of the proper law of the contract that you're fighting about.
That's our submission as to what C&D says, and on that...
I mean, the first step is to identify the term of the contract that you're seeking to enforce by injunction, isn't it? And you can only identify the terms of the contract by applying a system of law, and that system is the law which governs the contract, the arbitration agreement here. Now, it may be that what the arbitration agreement then says, construed in accordance with that law, leads to certain consequences about what it does and doesn't permit, and those may depend on what the curial law which the parties have chosen says, or they may not depend on that. But the first step must be to identify the term of the agreement that you're seeking to enforce by injunction, and that surely will tell me how on any other basis you could do it than in accordance with the law that governs that agreement.
Well, on that, if I could go to the High Court, so 1197.
1197.
Yes.
It says there that in the second, it says, paragraph 42, it does not matter whether English law is or is not the governing law of the agreement to arbitrate. It's the curial law which governs the question of the validity of the award and challenges to it.
Well, that can't be right.
No, I'm struggling to see quite what point's being made there. Surely, if the basis for the injunction which is being sought is enforcement of a contractual term, which I think it was in C against D, then you need to identify the contractual term. I'm just repeating my Lord's point now. You need to identify the contractual term. You do that, if there's doubt about it, by reference to the proper law of that contract. And as my lady pointed out, you can have different proper laws of the overall agreement and as distinct from the proper law of the arbitration agreement. We're concerned with the proper law of the arbitration agreement. So you look to the arbitration agreement to identify a promise as to how disputes will be dealt with and what then happens after you have an award. Now, it may be that it doesn't matter in lots of cases that the law of the arbitration agreement, let's just say in C against D, even if it was the proper law of the arbitration agreement was New York law, but if you've chosen London as a seat, New York law would say, and it's an implied term in that context, according to New York law, that you can't challenge an award other than through the courts of the seat. Then you've got your promise that you're seeking to enforce by injunction.
I think all we're trying to do here is establish where the more or less universal rule that the curial law is the law of the seat actually comes from.
Yeah. Could I
don't think it's in dispute.
No, I don't think it is. No, but it's just important to get it right as a matter of concept. Before you answer, can I just ask you to look at paragraph 51 on page 1200? In that paragraph, Mr. Justice Cook does seem to follow through the analysis that we've just been suggesting is the correct one.
But in 53, he then seems to be talking about he seems to now be referring to the law of the agreed supervisory jurisdiction, which seems to be something different, potentially.
I think what may have confused things is that I think there was an argument in C&D, wasn't there, that because New York law was the law of the contract or of the arbitration agreement, so that was one of the arguments, that gave New York courts a justification for interfering with the setting aside the award. And I think what they're saying is that well, they're rejecting that argument, that because you've chosen a law to govern the arbitration agreement, that in itself gives some entitlement to the courts of that country to supervise the award. But that's not to say that it isn't the law governing the arbitration agreement under which you decide what terms are implied into it.
I think it's perhaps worth saying that it may not matter in our case, because it seems to have been accepted for the purposes of these proceedings that even though I think it's Pakistan law that is the governing law of the arbitration agreement.
That seems to be accepted.
That it operates in the same way as English law. It may have just be assumed sub silentio, but
yes. Nobody suggested otherwise.
Any evidence to the contrary.
Yes.
In which case, it actually this point, which we're on because we want to get the analysis right, doesn't actually affect the result in this case. But if you want to tell us that the analysis is wrong, now's your opportunity to do so. And I rather think, although I haven't read through C&D at both instances in detail, which I will do hereafter, but I rather think my Lord is probably right that the reason there was argument about, well, what's the proper law of the arbitration agreement, was because it was being an argument being floated that, well, if it's New York law, perhaps you don't get such a strict requirement to abide by the curial law of the seat as the mode of challenging the award. Because it's new law, it might have been said, somehow that lets in a wider jurisdiction for American courts, and therefore...
That was an argument being made, I believe.
Right.
Yes.
And therefore, the implied term, if it was New York law which governed the contract, would not have been as restrictive as the court found it was. But at all events, it does seem to us that, as my Lord was saying, that the starting point would be, well, what's the term of the agreement which you're seeking to enforce? If there's doubt about that, well, how do you resolve that? You have to resolve it by looking at the proper law of the arbitration agreement to resolve issues of interpretation of that agreement. I mean, do you dissent from that?
No, we would accept that, but we would say that the point from 16 of C&D that...
Is this first instance?
No, sorry, Court of Appeal.
Court of Appeal. Can you just give us the page number for that? Sorry.
1210.
Thank you. Yeah, so yes, make your point on paragraph 16 then.
So the whole purpose of the balance achieved by the Bermuda form, English arbitration, but applying New York law, is that the judicial remedies in respect of the award should be those permitted by English law and only those so permitted.
Yes, but I think this is the court interpreting that contract using English law spectacles to do the interpreting. Because as I think my Lord did point out that they've said, well, English law is the proper law of the contract. So in a sense, they don't need more argument than they put here to interpret the contract, because they're interpreting it according to English law, which is the proper law of the contract.
Well, if we go on in 16 rolls into 17,
Yes.
where it says, it follows that a choice of seat must be a choice of forum for remedies seeking to attack the award. Then it quotes from Mr. Justice Coleman in A and B, drawing the analogy that an agreement to the seat is analogous to an exclusive jurisdiction clause. Any claim for a remedy going to the existence or scope of the arbitrator's jurisdiction or as to the validity of an existing interim or final award is agreed to be made only in the place designated as the seat. And then Lord Justice Longmore notes that that's, in his view, a correct statement of the law. And then if we go down again, we looked at it a moment ago, but paragraph 20.
Yes.
Even if it's assumed that the arbitration clause was to be governed by New York law, it would not entitle the defendant to mount a challenge to the award in a country other than the seat of the arbitration.
Yeah, that's what they construed the effect of the arbitration agreement as being.
It does seem as though they've covered both options. So they positively said, in fact, English law is the proper law of the arbitration agreement. But at 20, they seem to be saying, well, even on the alternative analysis, if the arbitration clause is governed by the law of New York, that's still not an answer, because the implication, I think it must be as a matter of the law of New York, from choice of the seat as London, still carries with it the same inference that it's to be that and nothing else, which was the foundation for the claim for injunctive relief in C against D.
Well, I think it's not clear from 20 whether he's saying that that's the content of New York law, or whether he's saying that because you've chosen an English seat, New York law doesn't matter, even if it is the proper law of the arbitration agreement.
I don't think he's saying that it doesn't matter for the purpose of determining what the proper law of the arbitration agreement is. I think he's saying that he's rejecting Mr. Hurst's argument that because the parties had chosen, so Mr. Hurst said, New York law is the proper law of the arbitration agreement. That meant, as a matter of construction of the arbitration agreement, that it didn't preclude a challenge to the award in New York.
Yeah.
It's a little complicated how they interrelate, but there's conceptually two quite different questions being asked.
Yes, but it also didn't impact the choice of the curial law as English law also allowed on that case the English court to exercise its jurisdiction to issue an anti-suit injunction.
Yes, and that was based on the term which they'd found was implied in the arbitration agreement. It's a contractual basis, the anti-suit injunction there, and it is here too.
Yes.
It all depends, in the first place, on identifying what the parties have agreed.
Yes.
But I don't think this goes to
No.
undermine your main argument is we're not in dispute here. The curial law is English law.
Yeah.
Yes.
And you're saying that because it's curial law is English law, that means you cannot attack the award by applying some different law, as I understand it.
Or somewhere else.
Or go somewhere else.
Yes.
Yes.
So
and I don't think that's in dispute.
We're really just
Yes.
we're just arguing about. Sorry, this is a separate point. It seems to me about why you get to the curial law. In this case, we know what the curial law is. So it really, I don't think ultimately really matters how one's got there. Query whether there might be a few cases where that could have some sort of impact. But surely the question that we're focusing on is whether this is, in any sense, covered by the Curia law. Is it a challenge to the award and therefore governed by the Curia law, or is it not?
Yes.
That's right. I wasn't expecting this to be a point of great difficulty. I was just wanting to get the analysis right. But you seem to think that there's something very sinister about it, and that if you accept my proposition, it will subvert your whole argument. Well, it's up to you to decide, but...
But is it also the point, what we're discussing is whether, when they said in this case, any challenge, we read that at face value, meaning any challenge, or whether, as Mr. Landau submits, you've got to look at that in the context of the fact pattern that they were applying it to, and they meant any challenge like the challenge that was being made or threatened to be made in New York.
Or the kind of challenge that you can make under the relevant provisions of our Arbitration Act, which I think are referred to here, 67, 68, so forth.
Yes, and it's our submission that if it's another type of challenge, that it's going too far.
So what kind of challenges do you think they were talking about in C and D?
Well, let me try and, I'll try and develop that submission a bit more.
I mean, do you accept that they weren't talking about recognition and enforcement in a foreign country?
We accept that the facts of the case are that they weren't talking about recognition or enforcement, but
well, it's also, do you also accept that there's a distinction in our which is reflected in our Arbitration Act between challenges to the award under Section 67, 68 and so forth, and recognition or enforcement of award, which is dealt with in a different part of the Act?
Yes, although what we say in relation to that, though, is that, as Lord Justice Phillips said in the Court of Appeal, that if you want to raise the Article 5, if Article 5 is the basis of your claim in the foreign proceedings, you raise that in response to an application for recognition and enforcement. It's a shield, not a sword. Maybe I can start there.
Well, that's a question of just wanting to get the parameters clear. If you accept the basic distinction, then the next question is there may be an argument about the boundary of that distinction. But I was just wanting to check that you do accept that there is a distinction that needs to be drawn between a challenge of the kind that you can make under Section 67 or 8 or 9 of the Arbitration Act and a dispute about recognition and enforcement, which is different.
Yes, we do accept that. So maybe I'll try and build up both points. So I'll take, the first one, that Article 5 is a shield, not a sword. Paragraph 23 of our written case, we make reference to the Supreme Court decision in Dalla, which refers to a party which objects to the jurisdiction of the tribunal has two options. It can challenge the tribunal's jurisdictions in the court of the seat, or it can resist enforcement in the court before which the award is brought for recognition.
Well, you can't pluck that quotation out and say that that's a decision that you can't have a preemptive application to resist the award. It doesn't say whether it's not simply not contemplating that question. It didn't arise in Dalla. It's not how you read cases.
No,
look at the words and then give some literal interpretation.
My submission wouldn't work if that was my only authority. But I would like to use that as the.
It doesn't even say that you can't proactively resist the award, the enforcement of the award.
Well, no, but it does say that you have two options.
Yes, well, you do have two options. You've accepted that.
Well, the second option is resist enforcement in the courts before which the award is brought for recognition. in our submission, there's not a third option to preemptively or proactively raise the Article 5 defences.
Well, then you are plucking the words out and trying to build some point out of them that simply wasn't raised or discussed in Dalla. I mean, that doesn't get you anywhere.
Well, my lord, it is referenced in the Court of Appeal in Dalla. That's the quotation that we have in 24 of our written case. And there, Lord Justice Ricks is quoting from the decision of Justice Kaplan in Hong Kong.
So which page is this?
102.
Page 102.
Key document.
It's a quote within the submissions.
Ah.
But I mean,
but it wasn't an issue.
Point apply. I mean, this is looking at things in terms of the general framework of what can be done without going into the fine detail of all the procedural ins and outs of how you might achieve these things.
Well,
there was no issue in Dalla about whether you could preemptively oppose enforcement or recognition. So picking on some dicta and trying to attach significance to them doesn't help us. What we need to look at is the question in principle. And the first question is, why is it a matter for the English court to decide what procedures are available in Pakistan when Article 3 of the Convention says that rules of procedure are for the recognising or enforcing court?
Well, to that, I would build my submission based on the Pelling decision. So if we could go there, 1869, the sort of logic in the Pelling decision, and then I'll build it up by reference to the convention.
Yes. Which bit of it do you want us to look at?
The discussion, which starts at the bottom of 1874.
Yes.
So it starts with sort of going over similar paragraphs that we were talking about before from C and D. And then after the quotation from C and D, Judge Pelling notes that the principle has no impact on any challenge that BASF may be able to make to any attempted enforcement in Germany under Article 5 of the New York Convention. But it begs the question of whether in the circumstances of this case, as a matter of English law, it's able to maintain such a challenge. And then he...
But the first question is, why are we looking at English law for this purpose, given that England is not the place where the recognition or enforcement is taking place? So that begs the question.
The answer to that question, my lord, is going back to C and D and the bit that's quoted above at paragraph 13, that as a matter of English law, by agreeing to English law as the curial law of the arbitration, the parties agreed that any challenges was to be made in the English court, save to the extent otherwise permitted by English law.
But that was interpreting the arbitration agreement. They didn't say, what's more, and the parties have agreed that English law shall determine the scope of a foreign court's powers to recognise or enforce the award. They didn't say that in C and D, and if they had, it would have been a very exorbitant thing to suggest.
No, but they do limit you to, saying the same point, but they do limit you to challenges that are available to you to make to the award are those to be made in the English courts, save to the extent otherwise permitted by English law.
Yeah, those are meaning challenges of the kind stated in 67, 68, etc. Not questions of recognition and enforcement.
I mean, looking at the end of that paragraph 13, speaking for myself, it does read a little curiously. As to that, Integra submits that as a matter of English law, the right to rely on the defences set out in Article 5 of the NYC arise only where the party is seeking to rely on those defences for the purposes of defending itself against an application for the enforcement or recognition of an award. So that sentence is looking at what is happening in a foreign jurisdiction where under the New York Convention, it's the law of that jurisdiction which governs whether they recognise and enforce a judgment. Can you help us? I'm not following why the judge or why Integra is making a submission, which I think the judge is accepting, that somehow that is governed by English law. What happens in what is necessarily in this sort of situation a foreign jurisdiction?
Well, it's the same point that you're, by agreeing England is the curial law, you're limiting yourself to the remedies that are available. And so, like in C and D, where there may have been other remedies available as a matter of new law.
Sorry, just on that. The remedies available aren't those under Article 5 of the NYC, are they? When you're looking at the curial law.
Right.
Because Article 5 is looking at what the court of a jurisdiction, which is not the curial jurisdiction, does once an award has been produced within that curial jurisdiction and is then being taken around the world. Isn't that right? Have I misunderstood the way that Article 5 operates?
It's our submission that Article 5 can only be invoked in response to an application for recognition and enforcement.
I mean, I follow that part of your submission, but I'm here trying to understand what the judge was saying in this Integra case. Am I not right in thinking that Article 5 is, under the scheme of the New York Convention, something that only arises where an award exists and is taken to another jurisdiction, not the curial jurisdiction, and recognition and enforcement in that new jurisdiction is being sought?
Yes, and it only arises in
you say that can only happen
if,
if someone actually makes an application to enforce it. I follow all of that. But given that Article 5 only applies in that sort of situation, I'm struggling to see why the judge seems to be accepting a submission that English law governs the right to rely on the defences set out in Article 5, which is contemplating a case necessarily which arises outside the English jurisdiction, if London is the seat. I'm just struggling to understand what the judge is saying and whether you've got a submission that you want to rely on as to how I should interpret it.
It's my submission that what the judge is saying that if these additional rights exist in these other jurisdictions, but they are not rights that are available as a matter of English law, then by selecting England as the curial seat comes with it the power to injunct those proceedings.
But that would be irrelevant if you were seeking to recognise or enforce the award in England. Then you'd be looking at English law.
But my lord, I would draw the same analysis to the C and D facts. So there's a claim that the New York court has jurisdiction over. The English courts will look at whether or not that claim is a permissible challenge to an award as a matter of English law, because England has been selected as the curial law.
Suppose that Sweden was selected as the curial law and then a Swedish award was being enforced in England. Do you say the English court should look at how the Swedish courts interpret Article 5 to decide whether the application, what's the scope of the defences available in England to recognition or enforcement?
Or is it that if it was what you call a preemptive application, then we would have to, but if somebody is enforcing the award here, you are then entitled to raise the Article 5 points? I'm wondering whether what you're saying is that because there's no such thing as a preemptive application to recognise and enforce the award, any such application is in effect on the wrong side of Mr. Landau's line, and although it's purporting to engage the Article 5 grounds, in fact, because it's preemptive, it must be a challenge to the award that can only be brought in the courts of the seat.
Yes.
That's what you are saying, but the prior question is who decides whether Article 5 allows a preemptive challenge? And you seem to be putting forward a theory that it's always England.
Or the law of the seat.
Well,
or is it always the law of the seat? So that's why I ask you what would happen if it was Swedish seated arbitration and an application to enforce or recognise the award was made here.
Well, by selecting England as the curial law.
No, I'm postulating a choice of Sweden as the curial law.
Yeah.
But that's the point of my
example. And then there's a Swedish
So the arbitration has taken place in Sweden?
Yes.
So the arbitration has taken place in Sweden. Somebody here makes an application to recognise the loser of the arbitration.
Let's take the winner.
It could be either way around. The winner seeks to enforce, or the loser seeks a declaration for non-recognition.
Yeah, let's go for the loser seeks a declaration without the winner having tried to get it registered here as a judgment. The loser comes to the court seeking a declaration that if that the award is
not recognised in England,
should not be recognised under one of the Article 5 grounds. I think your case must be, but correct me if I'm wrong, that although that's purporting to be an application to recognise and enforce, it's not actually. It's not an Article 5 type case. It is a challenge to the validity of the award and therefore can only be brought in Sweden or Switzerland, wherever we are.
Sweden.
Yes, we would agree with that.
Right, but if the winner of the Swedish arbitration comes to London and tries to register the judgment here, then the loser can raise the Article 5 points because that really is recognition and enforcement. Is that right?
Yes.
So that's your case, but what I'm interested in is the first of my lady's propositions and how you get there. Because on this analysis, it would seem that you should look at what's permitted by the law of the seat, and so you'd look to see whether Sweden permits preemptive challenges in order to decide whether we should allow them or not. Is that your case or not? And if it's not your case, how can you have it both ways round?
Well, I understand that you would answer Swedish law.
Yes.
The logic of your position is the law of the seat governs these questions, and therefore it would have to be the law of Sweden.
Well, that is the logic, but I'm just wondering whether you follow that logic or you don't.
In that hypothetical, yes, we would, yes.
Yeah.
Are you aware whether it's ever been suggested in England that we should look to any other law than English law to decide what defences are available and what forms of procedure are available in recognition and enforcement proceedings?
Well, no, my lord, but I would say that on the other anti-suit injunction cases, you are prepared to injunct the foreign proceedings, even if what is going on in the foreign court is permissible in that foreign court. The question is whether what's being done in the foreign court, challenge the award, is allowed because England has been selected as the curial law.
Yes, thank you. Well, perhaps we should let you develop your submissions more fully now. Do you want to make further points on C against D? I mean, it does seem very important for your case. Were there other points you wanted to make on that? I'm not saying there should be.
No, I think I've covered everything on C and D.
To make sure that you've said all that you wanted to say on that.
Yeah.
So you found on paragraph 16 in Lord Justice Longmore's judgment that's the critical paragraph for your submission, is that right?
It is, my lord, yes. So look, to the point that to try and develop the point about the Article 5, Article 5 being only able to raise as a defence, I just want to look at some of the commentaries. If we could start with Redfern and Hunter, that's at page 4475. Paragraph 10.02 notes that right of appeal is the exception, and most arbitration rules provide unequivocally that an award is final and binding. It goes on to note that these are not empty words. One of the advantages of arbitration is that it's intended to result in the final termination of disputes between the parties. And then if we go to paragraph 10.05, Redfern and Hunter note that it's important to make clear a distinction between actions to challenge an award and opposition to actions seeking to recognise and enforce an award. Challenge to award usually takes place at the court of the seat, an attempt by the losing party to invalidate the award on the basis of the statutory grounds available under the law of the seat. In contrast, actions seeking to recognise and enforce may take place in any jurisdiction signatory to the convention or one that's adopted the relevant provisions. And then the final sentence, which is an important one for my submission: in such actions, the party against whom recognition and enforcement is sought may rely on the limited exceptions contained in Article 5 to seek to block enforcement. Right.
Mm-hmm. What happens if, and I appreciate you say this isn't truly our case, but suppose it were the case that you have a party to the arbitration and they like half of the award and they don't like half of the award, and say that the other half they don't like comes within Article 5. What are they supposed to do? They want to enforce the half that they like in another state, but also want to resist enforcement in that other state of the half they don't like. What are they supposed to do?
Well, it depends on the law of the state concerned whether it allows partial enforcement or it doesn't.
Yes, and it's our position that the general practice is that partial enforcement is permitted, provided the parts to be enforced don't go against the parts not to be enforced.
Right. So, but is the foundation of that answer, in effect, Article 3 of the New York Convention, which says it's for the law of the jurisdiction where enforcement and recognition is being sought. It's their procedural law that governs. Is that the basis for the answer that you've just given us?
Yeah, we would say there's still the prior question as to whether objectively or substantively what you're seeking is partial enforcement.
Yeah, well, that's why I framed the question in the way that I did to get over that hurdle, because I appreciate there's an argument about it in our case, but I was just putting to you, let's assume factually that is what you're seeking to do. It's not a ruse or anything else. That is really what you're seeking to do.
Then yes, we would.
So for that answer, you're accepting that it's Article 3 of the New York Convention that pushes the question of can there be partial enforcement in the way that I was putting to you in the jurisdiction of the where enforcement and recognition is being sought. It's Article 3 of the New York Convention that says, well, it's for their law to decide. I just want to make sure I've understood your submission.
Yes, I think that's right.
Right, thank you very much. No, I'm sorry, I stopped you going through Redfern and Hunter, so is there anything else you want?
Not on Redfern and Hunter, but there's sort of similar points in a number of the other commentaries about the Article 5 being raised as a defence.
I can't see how you can, even if it were, you can treat the word seek to block enforcement as saying that you can't do that preemptively. I mean, quite compatible. You can seek to block enforcement by making an application saying it's unenforceable, for a declaration it's unenforceable in this jurisdiction.
Well, the words I would alight on are the earlier words in this sentence, which is the party against whom recognition and enforcement is sought.
Yes.
Well, that's a slight simplification of the convention.
It's fair to say, isn't it, that this is we're looking at paradigm scenarios, and it might be said against you that we're looking at something rather more subtle here that can't be covered by a general statement about the paradigm situation.
It's a question of interpretation of the New York Convention, isn't it?
Yes. Maybe I'll just give you some references to some other scholars that make the same point. So, Bourne, which is in the supplementary bundle, page 9. And similar references also in the EWCA guide to the interpretation of the New York Convention. Bundle reference in the forward to that, and the reference is page 4220.
Yes.
Okay. I'll move on to my third proposition, which is that an attack or a challenge to an award is more than seeking set-aside or erga omnes relief in the foreign jurisdiction. It's invoking any jurisdiction other than that of the Sea Court, seeking relief that is not permitted as a matter of English law, or that could undermine or restrict reliance on an award. The ASI, the anti-suit injunction cases, as we say at paragraphs 32 to 37 of our written case, the anti-suit injunction cases injuncting foreign proceedings after an arbitral award, they all speak of the foreign proceedings or of new arbitrations as being an attack or a challenge, but without actually seeking to define sort of what constitutes an attack or a challenge. We say, as a matter of language, an attack is an action initiated with an intent to cause harm or damage or achieve strategic advantage. Importantly, it's enough to be seeking to cause harm or damage. It doesn't need to be looking to eliminate the thing forever. And a challenge is to raise an objection to something. The objection does not...
We're not construing a statute here. We're trying to understand what they were getting at. And they were getting at applications similar to ones in Section 65, 68. I mean, you could say that a dispute about recognition or enforcement is seeking to cause harm or damage in a very broad sense, but we have to focus in on the scheme of the Arbitration Act and the Convention.
It's our submission, my lord, that the cases, particularly the cases we refer to at paragraph 32 of our written case, they are injuncting proceedings and are doing something other than seeking set-aside or erga omnes relief in the foreign jurisdictions. And my lord, you made the comment yesterday that a number of them cover a situation where it seems that the parties are trying to relitigate issues that had been decided in the arbitration. And that's exactly right. So the touchstone for whether or not the courts were prepared to grant the injunction was not whether or not what was being done in the foreign proceedings was seeking erga omnes relief. It's broader than that.
Well, that's because there are two different parts of the two different duties that are implicit in the agreement to arbitrate somewhere. We're, on this appeal, I think, exclusively concerned with the implied duty not to bring a challenge to the award, to use that term somewhere else. We're not concerned with what seems to have been true in some of those other cases, that you're also promising not to bring litigation elsewhere in respect of what you agreed to arbitrate.
Well, which is your best case of the ones that you mention in your paragraph 32?
Well, let me go through some of them. So I'll start with them.
I mean, before we do, do you agree with my analysis of that there are those two limbs of the implied obligation, and that some of these cases, at least, are concerned with the question of whether you're seeking to litigate what you agreed to arbitrate, which is not an issue in this case?
Yes, but the point I draw from those cases is that the court was prepared to issue the injunction because the other proceedings were, just to take the first case we quote at paragraph 32, Noble and Goering, an attempt to reverse the effect of the arbitration award by a collateral attack.
Okay.
Should we look at that so that we can understand the context and the reasoning?
If I come on, I will come back to that case. I just wanted to go first to the case of Nomihold.
Which one, sorry?
Nomihold Securities v. Mobile Telesystems.
Sorry, that's not in this.
That's not in my list, but it's a decision of Mr. Justice Andrew Smith that was cited in Injazat that is in my list.
Okay.
All right.
So
Give us the name and the bundle reference if you wouldn't mind.
Okay, so that's page 2171.
2-1.
Yes.
Is the start of the case.
And its name was?
Nomihold Securities v. Mobile Telesystems. So in that case, the defendant lost an arbitration and was ordered to make payment to the claimant. And the defendant then pursued 2 further arbitrations against the claimant that sought declaratory relief that the defendant was not obliged to fulfill its obligations under the previous award. The claimant applied for an anti-arbitration injunction requiring the defendant to discontinue the new arbitration. And on the facts, the judge decided not to issue an injunction due to undertakings given. But nonetheless, Mr. Justice Smith did address whether he had jurisdiction to grant the injunction. And of relevance to my submission, I'd like to take you to paragraph 31, which is on page 2179. On the left-hand column, 6 lines down from the bottom, he says there, thus, it's a breach of an arbitration agreement to bring proceedings to make an unlawful attempt to invalidate the award or to make a collateral attack on a binding judgment or award of a properly constituted tribunal. And there he's citing from Noble and Gerling. And the point I wish to emphasize is that the judge is saying that the breach of the arbitration agreement is more than making an unlawful attempt to invalidate the award. Or to put it in the words of this hearing, it's more than seeking erga omnes relief. It is, in addition, making a collateral attack on a binding award or judgment. There's then similar dicta in
Sorry, can I just ask you this? Doesn't that fall within the pattern of my Lord Legate's second example, that it's in, part of an arbitration agreement that if you've arbitrated the matter, you will not litigate the same thing elsewhere? And this seems, as I understand it, to be all precisely within that pattern, because you've got the arbitration award, and what they were trying to do was litigate, arbitrate again to get to get that award, to get a different result, and as a result of second arbitration, have that award set aside in some way.
Well, that's right, that the relitigation is the attack. Is the point I'm trying to draw out, is that the relitigation and the attack thereof is something different and separate to seeking erga omnes relief.
All right, thank you.
It's broader.
But it can't be so broad as to stop an award debtor from raising Article 5 defences in the enforcing court in response to a claim, an application to register the judgment and enforce it, even though if those Article 5 defences are successful, then actually the result is that the award is challenged fundamentally, because the Article 5 defences include the invalidity of the award potentially.
Yes, we accept that, and then the line we would, in our submission, would be, it does preclude you raising those Article 5 defences preemptively.
Preemptively, because then you say that is in effect the same thing as a section 67 to 69.
Yes.
Yeah, and I think you must say that even if the prayer in the Lahore proceedings, as amended by Mr. Landau, purports to limit the effect of the Lahore High Court's conclusions to Pakistan. You say it would still be on the wrong side of the line that you're drawing.
Yes.
But how can it differ according to the timing of the application?
Well, he says it.
I mean, either it's either recognition enforcement is purely local, whenever it's decided, whether before or after something's happened elsewhere, or an application's been brought by the to enforce.
It's not about.
It's the nature of the relief, isn't it, that matters? Is all that's being sought a decision about whether the award can be enforced or recognised in that jurisdiction, or does it purport to go wider and undercut the award generally and elsewhere?
My Lord, it's not about the timing. It's about raising whether you are entitled to raise the Article 5 defences preemptively or not. And if you take the step to raise them preemptively, it's our submission that is a.
But it doesn't change the nature of what you're seeking to have the court decide, which is only whether the award is capable or should be recognised and enforced in that country, and not anything beyond that.
The same, in our submission, the same logic would apply when you're injuncting the litigation that is commenced in the other, the litigation in the other jurisdiction that somehow seeks to attack or undermine the award, presumably only have effect in that jurisdiction.
No, because if you've got a judgment in that jurisdiction, you could then start relying on that judgment around the world.
A couple more references. Similar to the paragraph in Nomihold that I'm taking you to there. There's similar reference in Injazat. That's in the bundle at page 1867, paragraph 22. And again, in the judgment of Mr. Justice Foxton, as he was in Sodza-Wiskney v. Smith. I'll just turn that up briefly. That's 2383. And paragraph 81 on the left-hand side, 9 lines down, Mr. Justice Foxton is commenting on Injazat and noting that Mr. Justice Flo was prepared to grant an anti-arbitration injunction in that case because it was clear that the proceedings were a transparent attempt to frustrate enforcement proceedings in the first award, even though the injuncted arbitral claim was not expressly framed as a request to set aside the prior award or to nullify its effects. And there's similar language in the anti-suit injunction cases in other jurisdictions. I could just show you two of those quickly. Hilton and Son Travels is a decision from the Singapore High Court. That's at 3246. Paragraph 54. Five lines from the bottom. The agreement to arbitrate implies a negative obligation that, following an agreement on the seat, the parties would not set aside or otherwise attack any issued award other than through the mechanism provided for in the seat.
What kind of attack was going on in this case? Well, if you're not relying on it for what it decided, but just for that.
I will get back to you on that. It's more I rely on it more of the statement of principle. Slightly fuller notes on the Hong Kong case I wanted to take you to, which is G.
Well, sorry, just on paragraph 54, I mean, the last sentence specifically carves out, this is obviously distinct from the enforcement process, where an award debtor is legitimately entitled to resist enforcement in any jurisdiction in which enforcement of the award is sought. So, I mean, it's not going to be good enough just to say you can't challenge an award, because in a certain sense you can. Every time you go to a new jurisdiction seeking recognition and enforcement, if you've got an Article 5 defence, you're entitled to put it forward. Anyway, take us to the next authority that you wanted to go to.
The next one is from Hong Kong. It's G and CNG, page 3186 of the bundle.
But as I understand, your submission in answer to my Lord's question would presumably be that the line is being drawn at using the New York Convention as a defence.
That's right, my Lord, yes.
So it doesn't amount to a collateral attack if you're using it as a defence. But insofar as you're using it in other ways, you would say it falls within the forbidden collateral attack, and you decide all that by the law of the seat rather than applying what I would call Article 3 under the New York Convention. In other words, where the line is being drawn, as I understand it, your submission is it's all for the law of the seat. And what the law of the seat is saying is, well, there is a line, but it's only where defensively you're using the New York Convention and not offensively or for a preemptive attack. Is that?
That's a fair summary, my Lord, yes.
So you would say the last sentence here is within exactly what you're saying?
Yes. So just on this Hong Kong case, the underlying dispute between the parties arose out of a share purchase agreement and a related shareholders agreement, and the claimants commenced a Hong Kong seated arbitration against the defendant and obtained 4 different partial awards in their favour. And the claimants also obtained enforcement orders from the Hong Kong courts in respect of 2 of those partial awards. The defendant then commenced a new arbitration against the claimants, which it defined as the bribery arbitration. seeking both set aside of the prior awards, but also rescission of the underlying contracts and damages. And the claimant sought an injunction to restrain the defendant's pursuit of the
Where did they try and issue that?
Sorry.
Where did they try? Oh, they started.
It was an arbitration.
It was an arbitration.
Another arbitration, yes. And I want to take you to paragraph 47. It's a judgment of Mrs. Justice Mimi Chan. The paragraph 47 is on 3196. And here she's dealing with an argument from the defendant concerning Article 34 of the UNCITRAL model law. And the defendant argued, Article 34 of the UNCITRAL model law provides at paragraph 1 that recourse to a court against an arbitral award may only be made by an application for setting aside in accordance with paragraphs 2 and 3 of that article, and paragraph 2 of Article 34 sets out the grounds for setting aside of an award by a court, and the grounds there largely mirror Article 5.1 of the New York Convention. Article 5.1 and 5.2 of the New York Convention. And then, so the defendant here also argued that the law did not preclude it making this fresh arbitration to set aside the award for fraud, because it said Article 34 only regulated recourse to a court to set aside an award, with recourse meaning the means by which a party may actively attack award. And so the defendant then argued that the law did not prevent it from arbitrating its claim to reopen previous awards tainted by bribery or fraud. And thus it was not a direct attack or a collateral attack on the awards. As you'll see from 47, Madam Justice Chan found this argument unavailing. She said, "Nor do I accept that recourse should only cover a direct attack and not any form of indirect attack. As in any case before the court, the focus should be on the substance of the application and dispute, and not how it is framed or articulated in technical lawyers' jargon. The real issue for determination by the court is whether the substance of the application is to impugn the award and seek to relieve the parties from their obligations and rights under the award." And there's 2 points I wanted to highlight from this passage. The first is what she says in the final sentence, where she says the real issue for determination is whether the application, so that's the foreign proceedings, or on the facts of that case, the new bribery applications, are trying to impugn the award and seek to relieve the parties from their rights and obligations under the award. And that, in our submission, is an accurate articulation of what constitutes an attack on an award. Impugn means to fight or attack with words, to challenge, criticise, call into question. You can impugn something without trying to eliminate it or destroy it. You can impugn an award without seeking erga omnes relief. And the second point I wish to highlight is the reference to the court being focused on the substance of the dispute and not how it is framed or articulated by the lawyers. And that brings me to my fourth proposition at the end of my written case, is that when determining whether the foreign proceedings are an impermissible challenge or attack on the award, that the English court should be looking at the substance and not the form. And I say that's particularly relevant on the facts of this case, given the appellant's past conduct in relation to the Atlas Power case. And you were taken to the Atlas Power case yesterday by my learned friend. there are a couple of more points I would like to make in relation to the Atlas Power case, and I'll try and get them in before the lunch break. That case was in 2017. And it involved a group of other foreign power producers in Pakistan known as IPPs, led by a company called Atlas Power. And there's a reference to the case at paragraph 18 of our written case. Now, those IPPs all had similar PPAs with NTDC to the one that's in this case. And in that case, there was also a London-seated LCIA arbitration award issued in favour of the IPPs. But similar to this case, instead of paying the sums ordered, NTDC tried to bring a challenge to those awards in Pakistan. And in a quirk of fate, they ran into Mr. Justice Phillips in the High Court as he was in 2017, and they ran into him again as Lord Justice Phillips in this case. And the point was made yesterday that the proceedings were different. One was brought under the Atlas Power case was brought under the 1940 Act, whereas the current case is brought under the 2011 Act. The point I wish to sort of draw out, based on the sort of warning sounded by Madam Justice Mimi Chan, is to look at the substance of what the complaint is and not how it's framed in, to use her words, the technical lawyer's jargon. Because it's my submission that the crux of NTDC's complaint in Atlas Power and its complaint now in the Lahore proceedings are very similar. And we can see that if we turn up NTDC's application in the Atlas Power case. You were taken to this document yesterday. It's page 505 of the bundle. And that's the start of the application, or the extract of the application. Not all the pages are there, but I want to take you to page 5113. And at the bottom there...
sorry, 513, I think.
Yeah, sorry, 513. So the grounds of challenge, A, is that the tribunals proceeded without jurisdiction, and B, is that the award is invalid and inconsistent with the laws of Pakistan. And so my suspicion, that's very similar to the complaint being made now in the Lahore proceedings.
But suppose Star Hydro had sought to enforce the award in Pakistan, in the Lahore High Court. They'd issued proceedings saying, we got this award, please make it into a judgment of your court. And back had come a defence from National Transmission, setting out exactly this same grounds of challenge, saying the award is null and void ab initio. Do you say that the English court could have issued an anti-suit injunction to tell them, no, you cannot defend yourself against Star Hydro's application to enforce the award by challenging the award and saying it's null and void?
That's what I would say is the sort of right side of the line, because we have, once we've invoked the jurisdiction.
So it's not really the nature of the relief they're seeking, because they would be seeking exactly the same relief, but by way of counterclaim, as it were, rather than claim. And that, you think, would be fine. But so the real problem here is the preemptive nature of it.
Yes.
That's what I thought you were saying, but I just wanted to.
I mean, in the earlier case, they were explicitly asking for the award to be set aside, weren't they? In the paragraph you just showed us, the award is liable to be set aside. So isn't the critical question whether you're seeking to have the award set aside, which clearly is a challenge attack within the C and D case, or whether you're simply objecting to its recognition and enforcement locally?
Well, this is the this in my submission is the warning about why you should be looking at substantively what they're doing.
There wasn't any doubt in what's it called, Atlas Power, was there? Because there it is. The award is liable to be set aside. I mean, that's what they were wanting the court to do.
Yes, exactly, my lord. And so
yeah, they're proceeding under an act which doesn't give the court that power even. It's a bit hard to see why it's a covert attempt to set aside the award when the only act they're relying on is one in which expressly, specifically, the court doesn't have that power.
it's our submission, my lord, that when you look at the substance of what they're saying, even if they say it's under the 2011 Act, asking for the declarations that all of the operative parts be declared a nullity, asking in the eyes of the law, asking for quantification of the award as zero, asking to injunct Star Hydro, that in substance that is the same or similar attack and shouldn't be, in our submission, swayed by the labels assigned to it. That's the warning Madam Justice Chan is giving.
But that's going to, I mean, I struggle with this a little bit, I have to say, because we know that some of the Article 5 grounds are equivalent to, well, taking the uncitral Article 34 grounds for challenging an award. So there isn't a nice clean line where you can say we're not challenging the award. That's precisely what you're doing under Article 5. You're challenging the effect of the award. It's just that the challenge is within the jurisdiction in which recognition and enforcement is being sought. I mean, I'm just speaking for myself as to why I struggle a little bit with this. Well, look at the substance, not the form, when the substance is going to be the same. If you're legitimately challenging recognition and enforcement under Article 5 in a particular jurisdiction,
the grounds will be exactly the same.
Will be the same.
It's what they lead up to that makes a difference, that matters. Do they lead up to a set-aside order? I mean, the mischief is that you go off to some favourable jurisdiction, your home jurisdiction, and you get a judgment there setting aside the award, and you then go around setting up that judgment as a defence to any attempt to enforce the award elsewhere. That's what the anti-suit injunction is trying to stop. But if all you get at the end of the procedure is a decision that the award can't be enforced or recognised in that local country, that's not going to help you anywhere else.
Well, it may or may not, depending on the other countries'
Well, it might, but only if they decided to follow a similar path, not because the award would have been set aside and therefore a defence would have been created under Article 5(1)(e).
I also must say that the substance form argument, I understand entirely why lawyers are framing particular types of relief and so on. But isn't it a very difficult argument to run if the actual basis specified is a particular statutory framework, and that statutory framework does not permit setting aside. It's hardly a question of form and substance, is it? In the same way that we all understand, you know, legal jargon, etc.
Well, it's our submission, my lord, that the specified relief in the Lahore prayer is going much further, and so you have to be careful about saying it's only under the Act. You need to look at what they're specifically asking for, and that's the substance over form point.
That may be a convenient moment on which
Yes.
to close for this morning. So we'll adjourn now and resume, please, at 2 o'clock. Thank you.